There we go. All right, chapter 12. This is where we're talking about the leases, landlord and tenant. In this chapter, we talk about actual eviction, Americans with disabilities. We're going to go through the property management, demising clauses, state lease, ground leases, holdover, implied warranty of habitability. Okay. Talk about the lessor, the lessee, net leases, all that kind of good stuff, tenants at will, truth in renting. So a lease from an owner of real estate, I'm on page 156, a lease from an owner of real estate known as the lessor. So the landlord is known as the lessor. The owner of the property is known as the lessor. The lessee is the tenant. And the owner, the lessor, transfers certain rights to possess and use the owner's property for a specific period of time. Right? So when we go back to chapter 5 and we talk about the bundle of rights, part of those bundle of rights get transferred to the tenant. All right? They transfer the property, as we call it, in what they call the legalese, is called the demise. So that's a new word we got to make sure we highlight and understand, because we're going to see that word throughout this chapter and also in questions that we will have with regards to that. Could you turn those lights on for me, please? Thanks. I'm sorry. So the transfer of the property by lease is a demise. Okay? There we go. Let there be light. The lease is both a contract and a conveyance. And the conveyance, again, is we're conveying some of the bundle of rights to the lessee. Enjoyment of the property, right to possess the property. The lessee, the tenant, cannot transfer the property or dispose of the property. They cannot will it to their heirs. So there's certain parts of the bundle of rights that they cannot do, but there are specific rights that are transferred. Now, New Jersey, the statute of fraud requires that for leases that are 3 years or more, they have to be in writing. So now that goes back to the same question and discussion that we had as far as, can contracts be oral or written? Well, in the beginning, it could only be written. But now, New Jersey says they can be oral too. And a contract that is written will hold up, will proceed over top of one that is just an oral contract. And you can sue for an oral contract. Now, one of the issues, now again, this is just in general, but when we're involved, there's going to be a contract. All right, so we cannot get paid unless there's a contract. That's the kind of the bottom line. So as a real estate service, real estate brokers, real estate salespeople, we have to have a contract in order to get paid. That contract with the lessor is going to determine how much we get paid and the start of the contract, the termination of the contract, and so forth and so on. Okay, but contracts in general, they can be oral, can be verbal. However, when it comes to the enforcement of the contract, the one that if it's written, it does proceed over top. Okay, it also may be recorded, which is interesting because when we think about recording stuff at the courthouse, the county clerk, we would think of like a deed being recorded or something along that line. Okay, you can also, as a business owner, and most companies do this, if they're leasing you a copier, $50,000 copier, you bet your bottom line they're going to put it on record that you have a lease obligation with them, so that when other creditors go to extend credit to you, they can see that you're obligated. So, because if they didn't do that, then someone could easily just go out and jack up all of their creditors, right? Get all kinds of credit and then bail out on it. So what they do is they do record those. Same thing with a lease. If a lease is more than 2 years, it can be recorded. Now, why would you record it? Well, for the same reason, right? Because you want to show that that person is obligated to pay this. Because who's to say that I'm not going to go out and obligate a lease with this one and obligate a lease over here and obligate over here? And now I'm extended far well beyond what I'm capable of. So recording it is not a bad idea. You can go down to the courthouse and do a search. When we use the National Tenant Network as our means of screening tenants, well, part of what they do is they scour electronically through the public records to find anything that would be recorded. And that's where it would show up. So if I have a 2-year lease with, landlord A, and I'm trying to get another lease with landlord B, if it's more than 2 years and it's recorded, it will show up and at least give us the option of knowing whether this candidate can or not afford all of their obligations. Okay? And also, for us, if we're going to sue for our commission, the lease has to be in writing. So we can't just sue for commission based on a verbal agreement. All right, keep that in mind. So as brokers, that's an important feature, because I think a lot of times, agents don't realize. They just say, okay, well, we'll just get the rental for you. And it's got to be in writing for us to perform that service. All right. Now let's jump into the more specific parts of here. More specific parts on 157. There's a little table there, 12.1. It kind of that table. Sometimes these tables are good to define the different types of leasehold estates, because that's what we're talking about, leasehold estates. In the previous chapter, we talked about the other types of estates, right, where you can have freehold estate, and this was that other little part called leasehold we said we would get to in another chapter. Well, here we are. A tenant's right to occupy land is called a leasehold estate. Each leasehold estate has distinguishing characteristics. Number 1, estate for the years. 2, periodic estate. 3, tenancy at will. And 4, tenancy at sufferance. So the estate for years means that it continues for a definite period of time. And you want to highlight this. So estate for the years continues for a definite period of time. It has a specific termination date. Upon termination, the termination date, the tenant must vacate the property. There's no notice that's required at the end of the lease. So if you have a 12-month lease, you start January 1st, it ends December 31st, you're expected that on December 31st to vacate the property and return the property in its condition that you found it. It also, this type of lease may be terminated prior to the expiration date with mutual consent, so both parties can agree to terminate. However, if they do not mutually agree to terminate, it would be a breach of contract, breach of the lease. Okay? In some cases, the leases may also stipulate that if they're going to renew, that they have to renew within a certain amount of days prior to the expiration of that lease. Typically, that's, in my leases, I put 60 days. That gives me plenty of time to try to market the property and find a new tenant. Some people put 30 days. Some landlords don't put anything at all. Okay, and they don't realize that that day, the last day of that lease, when it terminates, the tenant is expected to move out. If they do not move out, that's called a holdover. And we're going to get to that in just a second. These contracts, the estate for years, may also be long-term or short-term or a fixed term. In other words, from point A to point B, say for month to month, this month, and then it's done, you're out. Or for 6 months, and then you're out. It begins and ends. This is what you need to highlight and understand. It begins and ends in time. Now, periodic estate, which is the second one in line, automatically renews. Okay, so this is an estate from period to period. It continues for an indefinite period. There's no specific expiration date. The rent is still paid at defined intervals, and the lease runs for a certain time, say like a month to month, week to week, or year to year, and it automatically renews until notice is given for termination. So it's possible that you can go from one to the other now. If you start to think about it, we can have an estate for years, which is a defined period of time, say 12 months, January 1st to December 31st, and then from January 1st of the next year, it could go on a month-to-month basis, and at that point, it would become a periodic estate. So you can go from one to the other, so long as you have agreements, mutual consent by both parties. If the landlord does not agree to this and the tenant stays over, it's called a holdover, and then we'll jump to what's called estate at sufferance, and we'll talk about that on second. So periodic estate, the creation of it, month to month, is created when the possession is taken with no definite termination date and the rent is paid on a monthly basis. A year to year could also be created where the tenant, for a term of years, remains in possession after the expiration of the lease terms. So it's quite possible that you could go estate for the years, 12 months, definite start, definite stop, and then continue to remain in the property for periodic estate for another year with no lease in place. And that's what happens. So we say, okay, well, the original lease will prevail. The original lease does not prevail to an extent, or does prevail to an extent, in that you can refer that back to those terms. But really what happens is we go from estate for years and we jump to a periodic estate in terms of its timeline. Because I've had, tenants and landlords, that we've put into service. After a year, the tenant wants to stay there. And then 3 months into it, they say, okay, well, I'm done. And the landlord says, well, wait a minute, you stayed and you're good for another year. The answer is no. Unless they put a new lease in place, it becomes a periodic estate. If they stay there and pay in monthly intervals, then it's expected that they would give the same amount of time to release or terminate the contract. Does that make sense? Okay. Again, with with periodic estate, we have this thing called holdover. So a holdover tenancy, it remains in possession of the lease after the term, against the will of the landlord. And that's key to understand. It's against the will of the landlord. So the landlord could do one of two things. They could either evict the holdover tenant, or they could accept the holdover tenant. Now, what does it mean to accept? Well, obviously there could be a verbal acceptance. It could be written in writing. Or if that landlord accepts payment from that tenant, they have accepted a contract, because the payment is an obligation. It's a payment of debt, whereas it creates a contract. And that's why we need to make sure it's clear. So if a tenant's paying by cash, it's harder to prove unless you subpoena the records of the landlord to see that a deposit was made in the same amount that was made, same tender as before. Whereas if a tenant's paying by check or by money order, they can at least copy it and track it and say, well, hey, I paid this same amount this month that I did for the last 12 months, which now makes us a periodic estate. You've accepted it, therefore, we have a contract. What kind of contract do we have? What kind of contract do we have at that point? We've got a periodic, right? So it will only be from the month to month or whatever it may be. Okay, you see that? And that's what's got to be clearly understood. And this comes up a lot, and it'll come up even more for you now that you have this knowledge. Because now we'll be able to better explain those leases and we won't have those ongoing problems. Okay? So it's a tenant that remains in a property after giving notice may be held liable for double the rent. Okay, so that's one thing. So a tenant that remains after the notice was given to terminate may be liable for double. And that would require the landlord to take the tenant to court and go through that whole process. So when a lease term is no longer 1 month, the landlord may commence proceedings to remove the tenant as a holdover tenant, which means go through the eviction process. Now the termination, again, of a periodic estate. So if the landlord accepts the rent from any holdover tenant, this creates the tenancy from month to month. We just talked about that. To terminate, both the landlord and the tenant must give proper notice. Now, what does proper notice mean? Well, at the end of the month tenancy, 1 month's written notice is required to the date of that the rent is due. So in other words, if you are on a month-to-month, January 1st to January 30th, or 31st, right? There's 31 days in January, I think. Okay? If you were going to terminate and move out February 1st or be out of there 31st, you would had to have given notice on the 1st for your 30-day termination. Does that make sense? Okay. The final one we have is what's called, I'm sorry, not the final one, but another one we have is called tenancy at will. This gives the tenant the right to possess the property for an indefinite period of time with the consent of the landlord. So the landlord has to be agreeable to it, and it could be for an indefinite period of time. It's created by expression. Okay, it could also be created by operation of the law. Okay, during its existence, the tenant has all the rights and obligations of a lessor-lessee relationship, including the payment of the rent. So this could be, they give you an example here of a planned condominium conversion. So if there's a condominium conversion taking place, the tenant will stay there for as long as they can until the new project is ready to commence. Sometimes when you're converting a condominium or apartment, you can convert condos and sell them. But if you have a tenant that's in there, they can stay there until the wrecking ball shows up to knock it down. That's essentially what this means, tenancy at will. It means they have the right to possess the property for an indefinite period of time with the consent of the landlord. Otherwise, they would be considered what we call squatters, but they would be there against the landlord's will, without their consent, which then puts us into what's called tenancy in sufferance. This arises when a tenant who lawfully comes into the occupancy of the property retains possession without the landlord's consent after their rights have expired. Example, you got a 12-month lease. We started off with what's called estate for the years. January 1st to December 31st creates an estate for years. The landlord is expecting that the tenants to move out on the 31st, and they have a new tenant moving in on, let's say, the 1st of January, the next year. But the original tenant does not move out. The landlord instructs them that the lease is terminated and that they have to vacate the property immediately. They refuse. That's called a tenancy in sufferance. It's also called a holdover. It's only a holdover if the landlord accepts it as a holdover. So technically it's a estate for years, holdover, and now it's a tenancy in sufferance. It creates kind of a mess, doesn't it? It's not confusing at all. Not confusing at all. And yet on the test, on the exam, you're going to have questions with regards to this. And, as we get moving into the broker side of things, it's important that we understand this point. Now again, preface by saying that if there's ever a dispute with landlord-tenant, we refer them to an attorney. Because New Jersey has specific laws regarding the landlord-tenant. And we can find all those laws, by the way, in the Truth in Renting book. Okay, if you don't have a copy of it, it's on our system. It's on our Loop Cloud, or whatever you call it. And if you'd like a copy of it, just let me know. I can send you a PDF version of it. It's called the Truth in Renting. Those are basically the landlord-tenant laws. And it's important, I think, as brokers, as agents, as landlords, as tenants, to read that book and understand it fully. Because sometimes the interpretation of things such as security deposit. We had a class on Saturday, right? It was a rental class that was put on by one of our agents. Okay, and they called in. We had a question regarding security deposit and pet deposits. Yeah, things like that. So it's clear in the handbook how it is to be interpreted and what the rules and regulations are. Do you have a question?
No, I was going to say that.
Okay. Mm-hmm.
Hey.
In New Jersey, yeah. And remember, that's a month and a half. Yeah, and understand, each state is different with regards to the security deposit. So we have to, if we're going to be dual state licensed, we have to remember the rules and regulations for each of the states. Because here it goes. You're licensed in Pennsylvania, right? And over there, it's, first, last, and 1 month security. Okay? So you come over to Jersey, you're collecting first, last, and 1 month security, and now you're in violation. Mm-hmm. Hmm?
Specific. Go to this class because I know first I requested.
Yep.
First month.
Last. Yeah. And that's what happens. A lot of people do that. You'd be surprised. Yeah. Yeah, and you'd be surprised. I mean, and I've run across landlords that say, nope, I want first, last, and middle, and this and that. I'm like, oh, hold on, cowboy. You can't do all that. Here's the handbook, and here's what it says. And then they say, well, what about pet security deposit? Well, there's no such thing. If you take a deposit of any type, whether you call it a pet deposit, a chandelier deposit, or whatever you call it, if it's called a deposit, it cannot be more than 1 month and a half. It could be a cleaning. It can only be a cleaning fee, but you have to provide the services. So what we do in the case of pet deposits, we don't call them pet deposits. We call it a non-refundable pet fee. It's non-refundable, and we got to specifically put that in the contract. Therefore, we can take that fee, or we can say, well, we'll spread it out over the lease. In each month, you will pay $50 more. Here's the problem. Your tenant moves out halfway. This is my issue with doing that way. Your tenant moves out 3-4 months into it, and their pet destroyed the place. Did you collect a pet fee? Yeah, $50 a month times 3 is not going to cover the cost of the pet. So I want a non-refundable pet fee up front, and that way at least I have that, and then we can look at the security deposit for damages that were done as well.
So I'm
You can only take, all right, so the way, and we'll get into that, but let's talk about it now. So the collection of deposits and rent, if somebody moves in on January 1st, the rent is due January 1st. So you got the first month rent, all right, plus 1.5 months of security deposit. And that's it. Because it's non-refundable pet fee. It's non-refundable.
So it's a fee, not a deposit.
Correct. And it's non-refundable. Because your deposit money is refundable, it's got to be accounted for within 30 days of the termination of the lease, minus any repairs. Now, the key and the caveat here as well, we're getting a little ahead of ourselves, but the key and the caveat is that with a security deposit, let's say your tenant destroys the place. You have a 1.5-month security deposit. You have to send them an accountability letter showing them this is the repairs that you made to the property. Now, you're supposed to give them an opportunity to repair that on their own and not take it from security deposit. You see? So, but a lot of people don't do that, which is why we should do an exit interview, an exit walkthrough with the tenant. Now, if they just pick up in the middle of the night and jet, well, then that's an issue. But we still have to go through the same process of accounting for it. And it also states in the lease handbook that you cannot use that security deposit for payment of rent. Now, if you want to do that, you have to take them to court. They may not show up in the court. The judge will give you a default judgment, perhaps. And you're going to tell them that you want to apply that to the loss of rent. You got to read it. It's in the handbook. It's very clear that you cannot apply that to the rent. You can't use a security deposit for the last month's rent. A lot of people think, well, hey, I got security deposit, pay that the last month's rent. You can't do it. Can't do it. Now, you can do it with authorization, written authorization from the tenant, right? But here's the thing. I wouldn't do that. Collect their money, because then if they leave and they destroy the place on the way out, you don't have any security deposit to use to make repairs. So I would never do it that way.
Tenants. On those, and I say like I hold fast.
Got to pay the rent. Right.
Philly is worse. They think it's you got the no.
Well, and the thing is, when I articulate that to them, it says it's a month and a half, not your month's rent, because they're going to say, well, you apply it to the rent, and then you still owe them a half a month, and meanwhile they've destroyed the property, and they've lived there and occupied it, so it's a lose for the landlord. And so we have to make sure we're clear about the terms and how it works for both parties, landlords and tenants, so they understand. So tenancy at sufferance, get back on track, arises when a tenant who lawfully came into the premises, into possession, retains the premises after the term is expired without the consent of the landlord. It can be evicted at any time, and it's viewed as the lowest type of estate, whereas fee simple is viewed as the highest. Now, that's going to be a test question, I can assure you, that tenancy at sufferance is the lowest type of interest. Why? Because it's at sufferance. Nobody wants it. The highest one would be having full possession, fee simple. You have the possession right out the gate. Again, I like to refer back to 12.1, that leasehold estate table, because it kind of just lays it out for you right there. And if you're going to study anything besides rereading the chapter and the highlights that we're telling you, I would probably concentrate right on this chart, because it really just lets you know. And if you follow the path of what's going on and place it into these things, you'll see how it works. And you can start off with the state for years, go to period, and then it be an at will, and then it could go to a sufferance. So you could go from one to the next to the next to the next to the next. All right, but you can only have. That's pretty much how it works. Now, again, we talked about some lease provisions already, but a lease may be oral, it may be written, or it may be implied. All right, key thing is here, three of these. We talked about under the contract section of our book, the essentials of a valid contract. Now we're going to talk about the essentials of a valid lease. Number one, they have to have the capacity to contract. In other words, be competent and sane, if you will, if that's possible. Be sane adults. There has to be a demising clause. Now, we just learned what demising means, right? And what does demising mean? It means to transfer, to contract for lease. It's early, yeah, I know. So the demising clause has to be in there. It says that the let lease and take rent. So the demising clause is basically what it means. It means I'm going to let you lease it. I'm going to take rent for that. That's what the demising clause is. You have to have a description of the premises. Now, we don't do this often in our contracts. We have the address, but do we put the block and lot in there? Do we describe what type of property it is? We don't, right? And I don't think I've seen a lease that has all that in there. However, it would be wise for us to attach perhaps maybe the multiple listing sheet as part of that. But at least you have to have the address. I would put the lot and block in there, and it would say the tenant will be renting the premises located at such and such and such and such. Make sure it's all spelled out. Yes, sir. Yeah.
What is it?
Well, the hype is this.
Every time I'm like, because I just recently figured out how to find it. Like,
Yeah, the lot and block because the lot and block is specific to that parcel, whereas you may have 123 Main Street, and it could be in Sewell, right? And yet, if you put it's not specific enough because maybe there's another 123 North Main Street. Yes, so you have and now it could be a different town altogether. Maybe it's called details. Now, as brokers, we want to make sure that as agents as well, but we want to make sure that we're so detail oriented now, because if you're going to be in business as a broker of record, right, what happens is that you're now on the hook for everything. So if one little, and you got to, and here I tell everybody this, whether you're pre-licensed, whether you're a broker's class, whether you've been practicing, you got one job in this world, and that's to stay out of court. And a broker told me that when I first started. You got one job here, stay out of court. So do whatever you got to do to stay out of court. Because, when you're before a judge, especially in landlord-tenant court, I got to tell you that it's been the history that the judges favor the tenants, without a doubt. Now, whether here nor there, it is what it is. So we have to remember that we've got to stay out of court. So every detail that we can put in there to make it, like same thing, I reviewed a contract last night. It was 10 o'clock at night, and I was reviewing the agreement of sale, right? And the agent, thankfully the agent reached out and said, hey, can you review this contract? Well, under the clause, now each of the areas that we fill in the blanks, she had NA. Now, Kevin, from our class, we don't put NA and stuff. Because if you put NA, now you're taking and striking out a paragraph, essentially, and we can't practice law. So you put none. All right? She also put under additional contract provisions, nothing. Well, there's a ton of additional contract provisions, so it's the details. The devil's in the details, right? I think this is how the phrase goes. So if you have an attachment, like Opinion 26 notice is attached, it's not part of the agreement of sale. It's part of the agreement of sale, but it's not part of the contract. So we attach, in the back there, attached is the notice to buyer and seller. You have the lead-based paint addendum. So we have to put in there that this contract also includes the addendum for lead-based paint, which, by the way, you have to have an addendum for leases as well for the lead-based paint. It's federal law. And, any other clauses anything you attach additionally, you have to put in there. There was nothing in this contract, and it was fine. And I'm so glad that they have the ability to reach out and say, hey, can you review this? So I typed back a lengthy paragraph of everything that needed to be put in there, as well as the attachments that needed to be filled out.
So along with attachments,
yes. And here's the reason. Let's put our thinking caps on. We want to stay out of court. I'm reading a contract. I'm the judge, and I'm reading your contract. And I see just the agreement of sale. Does nowhere in there mention any addendums that are attached. And so page 1 is the Opinion 26 notice to buyer and seller. It's missing. Where is it? The lead-based paint addendum. It's missing. Where is it? In those contracts, it says that the buyer has the right, or has been given the right, to have a 10-day inspection of that property for lead-based paint. It's federal law. Where's the attachment that says that? So we're saying that there's additional stuff, but yet we don't have it. So if we mention it in the additional contract provisions, then it gives that person who's now reading the lease, the thought pops up and says, oh, there's more to this contract. Where is it? Because wouldn't it be important to know if there was an amendment to a particular paragraph that change the trajectory or the rights that that person has in that agreement or that lease or that agreement of sale, and it's not there, it could change a decision as to if you're in front of the judge.
All right, so a question of, so when you're doing it,
Mm-hmm.
to the referencing, again, an addendum is an agreement unto itself, without a contract.
Correct. And here's a great, it's a great question, by the way. So if you can't redo the contract as it is.
So that's why I was
Right. So if you have an addendum that shows up after the fact, or if you read the addendums that we are allowed to pre-print or fill in, it says it references a contract dated here such and such a date. Now the thing is, of course, yes, if that addendum does not show up, then who would know about it? Okay, and that's the one part of it. But when you have a contract that stipulates lead-based paint, that the buyer received it, there should be the addendum. It says the addendum is attached herein, and it's not attached, then we've got a problem. So any amendments and additions, see, if we change things to the contract, it's not going to be an addendum. It's going to be an amendment, change that occurred. And there's going to be some other correspondence back and forth, say with regards to the home inspection. Okay, it could be something regarding that. We're going to amend that paragraph rather than addend it and add to it. We're not going to add anything to that paragraph. We're going to change, perhaps maybe, something in the contract. And we do that through an amendment. We amend the contract. So once the contract's signed, it's done, fully signed, fully an executory contract. The only way we can change it is to amend it. Okay, yes, sir.
So, section 4. Then, would after step align.
Well, let me ask you a question. What addendums? If I'm the judge and I'm saying to you, Roderick, what addendums? And you're like, yeah, just the addendums.
Yeah.
They're going to look at it and say, what addendums? So yes, we want to be specific with details. Or again, remember, everything's about detailing and staying out of court and documenting.
Right.
So if we keep our documentation, keep it scanned, document details, we're not going to be worried about being on the docket.
Licensees and brokers should that would
Absolutely, brokers and licensees, anybody that's drafting, because we're allowed to draft a 1 to 4 family contract with leases and single lots. So any time we're allowed to fill in those blanks, it should be detailed.
in 2 years I've gotten that one.
Hmm?
I actually did it one time.
Okay.
And I said to myself, this is the weirdest crap in the world. Why'd they have this here? But they were right.
Yeah, you have to have all the details in there. And again, a lot of times we don't do that because we're such in a hurry to get it done that we miss. And what happens is when you're in a hurry, there's a problem that occurs. You're going to be before the judge, and the judge's going to say, you're a professional, you should have known better. Now, we can't practice law, I get that, but we're allowed to fill in the blanks, and we need to fill in the blanks with all those things that we need. All right, so moving on. So again, talking about the essentials of a valid lease. Number one, capacity to contract. They have to be, competent. The demising clause, the description of the premises, a clear statement of the term, meaning the duration. Just like our agreement of sales or our listing agreements, we have to have a start to stop date and how much commission we're getting. Same thing here, has to have a clear statement of the term, to specify the rent and how it's to be paid. So it's got to be very specific, not just the wishy-washy. It's got to be, you're paying $1,200 a month for this period of 12 months, beginning January 1st, ending December 31st. The total payments that you'll be making is $24,000 over the period of that term. The rent is due on the 1st. The grace period is on the 5th. After the 5th, you were considered late. Well, actually, after the 1st, you're considered late. Okay, because the term is due on the 1st. Now, I want to point out something else, too, about these leases. Do you realize that the lease, actually the payment of the lease is due at the end of the month, the prior month? You'll read that in the book here. The rent is due at the end of what your use is. So you use it, and then you pay for it. Okay? However, we always say that, nope, that's okay, that's the contract. However, we want the monies due on the 1st, and we're considering it late after the 5th. Because it's always paid in arrears. You pay for what you use, you don't pay for what you don't use. That's why we can't collect advance rent. We can't collect advance rent because what are we doing? It's a deposit. We can, however, have the tenant make out a check for each month dated for February 1st, March 1st, April 1st, May 1st, June 1st, but we can't cash it until they use the service. So there are people that'll take and pay the whole year in advance. We can't do that. You can't pay the whole year in advance because you haven't used it yet. Because what happens? Suppose that they're 3 months into it and they get transferred to Italy for work. Are they still obligated for that full contract? Well, there's a contract, so I would say yes. And the mutual consent is that we're going to allow them to get out of it for the transfer. So what happens to the rest of the money? If you were to pay it all in advance, does the landlord have to give it back? You see, it creates a big problem, which is why we can't do it. Because the landlord's going to say, well, I spent the money. I just got back from Italy on your money. All right? But so that's why we can't collect a full year in advance. We can't collect advance rent because it's considered a deposit. The only way is the way I just described, is they write out a check, dated, post-dated, for each month, and then the landlord doesn't deposit it until it's time to deposit it. I'm not saying it's not done.
Well, what landlord's going to say no?
Well, for sure, if somebody's handing you $100,000.
Okay, let me chase you down.
Yeah, let me chase you down. I understand, but you got to realize. Yeah, I mean, listen. I hear what you're saying. However, the way the rules read and the way that, someone, if they got in front of a judge and they said, well, we prepaid the whole year, the judge's going to be like, yeah, you owe them the money. They didn't use the service. So now that they paid you that $20,000 for that year's rent and they move out, you got to come up with the money. Because then they're going to go into court and say, look, we prepaid. Here's our check. We didn't use the services. And the judge is going to look at them and say, you got to pay the money back. So it's what's going to happen. So we got to be very careful with that. And I know a lot of people do it. I mean, there's no doubt. All right, specific payment on specifically how the rent's going to be paid. All right, the lease must also be in writing for a term of no more than 3 years. Also required by all parties. Now, all signatures. Here's the deal. All signatures being that everybody that's occupying that property, adults that's occupying the property, needs to sign the lease. Now, why do we do that? Well, because maybe I'm signing a lease for you to live in. And now I jet, and you're the one living in the property, but you never signed the lease. So it gives you one more person to go after when it comes time to collect. So all adults that are occupying the property must be on the lease. That way they're all on the hook, should there be a problem. Pretty much? All understood, right? It's just a way to keep yourself safe, and it also keeps there from being any confusion where I'm signing a lease and now somebody else is moving in, or my other half is staying in the property and that person's not on the lease. So now do you have okay, so here's the thing. So if I have a contract, you and I have a contract, and yet your spouse, let's say, or let's just go that way, okay? You move out and the spouse remains. Do I have a contract with the spouse? No. So how enforceable is that contract? Now I can't enforce that contract on the spouse. Yeah, I mean, what am I enforcing? Now that person is there, unauthorized, so now we have an automatic tenancy at sufferance. But I can't enforce the original contract of lease because it was never noted that that person was an occupant. Yeah. Well, that's, what, yeah, in Pennsylvania, the cases where there's no relationship, there's no tenancy, but then automatic tenancy is there's an implied tenancy that occurs, a tenancy at sufferance at best. But if we go back to the tenancy at will, estate for the years, period to period, and sufferance, there had to have been a prevailing lease in place for those to occur. So do we really have a tenant-landlord situation? Well, when you go to try to get them out of there, yes, they're going to look at it and say, well, it's an implied creation. If the person that's not on the lease, whether it be a spouse or an adult child or what have you, stays in the property, yes.
They're tenant.
Well, yeah, I see where you're going with that. Yeah.
If you say that they're tenant,
You have to follow the tenant landlord laws.
follow that.
Correct. In Pennsylvania.
If there's no lease, and then drags it out. So,
Well, because what happens is they're trespassing.
right.
So if you don't have a lease, then they're considered trespassing. And can you get them out quicker? Well, maybe that's what happens now, is that spouse who is now in there, now they're considered trespassing. So can you go to the local police and say, someone's trespassing in my property, can you please come remove them? See, it creates a whole other situation. And then they say, well, then it goes in the other direction. So it creates a lot of problems. Again, all adults living in the property need to be on the lease. Yeah, it's terrible. It's terrible. Okay, so let's talk about the use of the premises now. Provisions are going to be inside this lease, whether it be a lease for business or a lease for residential. Remember, we don't do business leases. It has to be done by an attorney. So let's talk about residential. So there may be restrictions as to what they can do in there. In other words, they can't have their own little small business operation out of your house that you're renting them. Or perhaps maybe they can't operate a daycare out of there. Because now they got kids in your house that are not on the lease. Somebody gets hurt, somebody dies. Who's going to be in trouble? The landlord's going to be part of that lawsuit. Okay? So there's got to be certain terms with regards to the use of the property. And there's also the term, the period that the lease covers should be precisely out and set inside the document. Bless you. So lease provisions, these are New Jersey requirements. Number one, all offers, contracts, now you need to know this for the test, and that's why we have it highlighted up here. All offers, contracts, or leases to contain the business relationship of the broker. We must have the CIS, the Consumer Information Statement, in all leases and contracts that we put together. The landlord and the lessor and the lessee rather, have to acknowledge the receipt of the CIS, which is the Consumer Information Statement, as well as there has to be the attorney review period language in there, which states that this is a legally binding lease that will become final within 3 business days. During this period, you may choose to consult an attorney who can review and cancel the lease. All right, see the attorney clause. It's got to be in all of our stuff that we do, everything. Okay? Federal law, we talked about it before. The lead-based paint disclosure must be part of a contract. Any housing constructed before 1978 must disclose the presence of known lead-based paint. Here's the thing. Whether your house was built in 2005 or 1972, you must put the lead-based paint addendum in there. We don't have a choice not to put that lead-based paint addendum in a contract that is new, a house that is new. If it's built prior to 1978, absolutely. If it's built after 1978, absolutely. It must be inside the lease agreements and also in our sales contracts. Okay? The statement must be attached to the lease. It's got to be signed by all parties. The lessor, the lessee, the tenant has to have a right to have that property inspected for lead-based paint. Okay? You also need to have the pamphlet, the lead-based paint pamphlet, attached to the contract so that the tenant, the lessor, knows their rights under that particular part. All right, so we had a spoiler alert. We're on security deposits. Okay? Security deposit guarantees the payment of rent and it safeguards against the tenant's destruction of the premises. Now, it safeguards or guarantees payment of the rent. Well, it does if you go into court and ask for the money to be applied to past due rent. Okay, that's what it's there for. It's also there for if the tenant destroys the property or just, creates a mess. Okay, but again, you have to give them accounting within 30 days of where the money's being applied. Residential landlords may charge no more than 1.5 months of rental figure as a maximum amount for security-based or for security, which is fixed by our law. And there's no maximum for commercial leases, so you got to keep that in mind. So if you have a commercial lease, there's no maximum. They can ask for the full year. Okay. The tenant side of security deposits, the tenant must be notified as to where the money's been placed. They have to tell them which bank account, which bank the money's being placed in. Yes, sir. Well, residential is 1 to 4 units. So anything above that is commercial, yes. Yep. So
In case that's a trick question.
it could be a trick question, and it may be that they say, a residential building with 5 units, And you got to immediately know that that's going to be commercial, because we can only do 1 to 4 family and single lots. Okay, so the tenants, again, they have to be notified what bank account, and in fact, it says in there what bank account number, not only the bank, but what bank account number, within 30 days. The money must be placed in an interest-bearing account. At the end of the term or periodically, the tenant's supposed to get their interest on the money that's sitting in the interest-bearing account. And you can have all the money from all your tenants in one account. You don't have to have certain specific separate accounts for each tenant. If you have multiple tenants, they could be all in one. But then you have to figure out how much interest do each of them get based on how much their security is, based on how much interest was paid out. It's more pain in the neck, to say the least. So the tenant is entitled to all but 1% of that interest as credit toward the rent each month or on each anniversary of the lease. So you can keep 1% of that interest. Again, what a headache. How much interest do you get in the bank account anyway? Like 0.5%. So what are you really getting out of it? It's an accounting nightmare. If the property is sold, guess what happens? The deposits have to be transferred to the new owner immediately. What happens if it's sold? The landlord must notify the tenants immediately. All right, and where to redirect. That's a test question that I do see come up often with regards to what happens if the property is sold. All right. Security deposits must be returned, minus itemized deductions for damages, must be returned within 30 days of the lease expiration. If the landlord fails to respond within 30 days, the penalty is double the security deposit, according to New Jersey law. It's pretty hefty. The tenant may not apply the deposit to the last month's rent, and the landlord cannot keep the deposit if only damage is normal wear and tear. So that's why, again, we do a pre-walkthrough. We do a post-walkthrough. If a tenant moves out in the middle of the night, I would go over to the property immediately, and I would immediately take photos, enter the premises, note damages. Can we change the locks? The answer is no. If the tenant moves out, breaks the lease, you cannot change the locks. They still have a lease. Innocent until proven guilty. If you change the locks on that property, you're now violating law. The lease is still in effect.
Oh, so it expires and somebody.
If the lease expires and they have moved out, yes, you can change the locks. If the lease expires and they're a holdover tenant, you cannot go change the locks. You can't lock them out. You can't shut the utilities off. You can't shut the utilities off as a way of evicting a tenant either. Even if they're a holdover tenant or a tenancy at sufferance, you can't go over there and shut the water off or cut the electric. Not even cut the electric off, but you mean shut the electric off. Yes, sir.
Let me give you an example. I'll give you a funny story. About 2 years ago, so I'm trying to. She wouldn't go, and so you're right. So I couldn't. I didn't although I wanted. So what happened was, and so the pipes were.
Mm-hmm. Right. Mm-hmm.
Strategy. I know it was gonna be. So.
Mm-hmm.
Now, and, that's, that's it. I said, listen, he just couldn't get over it, right? And I couldn't go back to bed because they was away. So.
The other part of this is that, if as a landlord, we have a habitability clause that we're going to go over in just a minute. So we have to make sure that the property is habitable. And if it's not habitable, what happens? Well, the township will come in and deem it not habitable, and then the tenant can move out to a different place. Does it terminate the lease? From that standpoint, does it terminate the lease based on it not being habitable? Well, I think that there's a process that we would go through to really determine that. Okay, so we'll get to that shortly, but the late payments, rent is due at the end of each month. That's the bottom line. So typically leases state that the rent is payable at the beginning of each month, though. We don't want them to live there for a full month and not pay for the services they used. But it's just like going to a restaurant, right? You order your food, you don't pay for it in advance, do you? You pay for it after you're done eating. Yes, if you go to a Chinese restaurant, you do. You pay you pay at the door, and you can hit the buffet, but you can go back as many times as you want, right? Allegedly, supposedly.
Right.
All right. So that's just the way it works. The rent is due at the end of the month. However, in our leases and most leases I've seen, it's due on the first, and that's the way it is. Late payments and penalties may be charged with few exceptions. Number one, senior citizens receiving Social Security, can't charge them late penalties. Old age railroad retirement pensions, can't charge them late fees. And other government pensions, you can't charge late fees. Okay? There are exceptions that are given with the 5-day grace. Again, that's about as long as I give you is 5 days. After the 5th day, it starts to apply, $50 late fee plus $5 a day until you pay it, plus the rent. And some people charge you more than that. So some legal principles of leases. So leases may be recorded in the county where the property is located when the lease runs for a period of 2 years or more. You're not going to run down there to the courthouse or to the clerk's office and record a lease that's 12 months. You may want to, but typically you're not going to. It's required if a tenant intends to mortgage their leasehold interest. Now that's an interesting thing because you can mortgage the leasehold. I have not seen that in my entire career, but I understand that it is available if they wanted to mortgage the lease. I'm not really sure how that would work, to be honest with you. I believe that what you would do is perhaps apply for a mortgage where someone else is paying for it. They're giving you the money for almost maybe like a Section 8. Maybe not, that's not even a right example, but we'll have to look into that further. But it's possible that their interest now, they can lease their interest, mortgage out their interest. All right? Possession of the leased premises, again, that going backwards, so the mortgage of their leasehold interest, you're not going to find that on the test. That's more so just information for you to get. Yeah, possession of leased premises, however, will be. So it's implied covenant that possession is given to the tenant. It's important to remove the holdover tenant as quickly as possible because once you give them and they stay there and you accept payment, okay, it's implied. And then when you accept the payment, it becomes an actual contract. So remember that we've got to get them out quickly so there's no holdovers. And you don't get them out by shutting off the utilities or locking the doors. That's against the law. Let's talk about improvements. I think that probably puts us up to about page 156, 166. Yeah, 166. Okay? So the tenant may make improvements with the landlord's permission. Here's the thing. But any such alterations generally become the property of the landlord. That's the whole thing. So any improvements that become property of the landlord are considered a fixture. So then we get into the question about shades, blinds, awnings on the outside. How about satellite dishes? Is that considered a fixture or is that considered personal property? Once they attach it permanently to the house, it's a fixture. It's a fixture. Now, it may be leased by somebody else. Maybe technically the unit itself owned by somebody else, but it's a fixture now, so the landlord owns it, the seller owns it. If permission is given to install a trade fixture, the tenant is required to remove that prior to the expiration of the lease. Property should be and needs to be restored to its original condition. However, if the tenant in business situation, if any trade fixtures post their vacancy, then it becomes the property of the landlord. All right? Questions so far? Okay. Here's where we get into that maintenance of the premises. Every lease has an implied warranty of habitability. It's an implied warranty of habitability. The guarantee that the premises is fit for human habitation. The tenant will not be subject to any conditions that are or could endanger their life, health, or safety. Okay? And the tenants do not have to make any repairs unless stated in the lease. That's another thing, because the tenants, unless it's stated in the lease, they don't have to make any repairs. Changing a light bulb, is that a repair? It's considered a repair. The light's not working, it's got to be repaired. The only way to repair it is to change the light bulb. One could argue that a $3 light bulb is not warranting your time to go down there and do it when the tenant can do it. But yeah, if it's not stated in the lease, now my leases contain a minimum that the tenant's responsible for. They're responsible up to $50. Anything over $50, meaning $51, then I'm responsible for the $1, but they're still responsible for up to $50.
How do you handle?
Well, I do, on my leases, I do send out, I have a contract with the pest company that once a year they go out and spray the outside. I just choose not to have bed bugs.
How do you handle it?
Well, I don't have that specifically in my lease. However, if it's a habitability thing, we got to get down to, well, how was it created? And again, I think it comes down to it's on the landlord anyway.
No, it is, but it's only it's only across the wall, wasn't the bridge. It could be here.
Yeah, I don't
have it in my lease specific.
bed bugs.
And it's responsible for that. Because, they call you all the time. Said the
Yeah, well, when it comes to pest control,
I'm scared of
so
that lease.
see, for me, I have in the lease that we will provide pest control, meaning that we spray the outside once a year. I think that if we do the walkthrough and say that you're noting that there's nothing here, that you're responsible for everything else going forward, is fine. But just make sure that they don't deduct that from the rent. It's got to be very clear, again, the detail, that you're not to deduct this from the rent because you think it's my problem. So having more details in the lease is a good thing.
And in my lease it says, tenant is responsible.
Yeah, tenant responsible for certain things.
So that, so we it was ice or something like that. Our guys go once a year. Goes out in June. It's it. That's fine, but bed bugs.
Yeah, it's got, again, going into the specifics of your lease is very important, okay? So the tenant does not have to make any repairs unless it's stated in the lease, but the landlord must make the repairs within a reasonable period of time. I would highlight that because that is a test question. In a reasonable period of time. So what's reasonable?
30 days.
Okay? So it depends. It's left open like that for a reason. If the landlord fails to make these repairs, the tenant may withhold rent until the repairs are made. Now, it's important to understand that if a tenant holds back the rent, what they should do is put it into an escrow account. Put it into an escrow account or give it to their attorney to hold, but they should never not pay it. By not paying, it is your breach of contract, or the contract. Okay? So, maintenance of the property. Again, people can make complaints to the local boroughs. They can also call the Department of Community Affairs for complaints. That's a state agency. The Department of Community Affairs inspects buildings of 3 or more apartments every 5 years, or at least every 5 years, for compliance to make sure that they're up to building codes and standards and things and so forth. If the rent is withheld, it should be placed, okay, here we go. If any rent is withheld, it should be placed into an escrow account or consult with an attorney for action. Where the landlord furnishes heat, okay, all rooms must be heated to a degree of 68 degrees from 6 a.m. to 11 p.m. and at least 65 degrees at night. That's what it states. Now, in my leases specifically, I put in there that you must, when the heat is on, not in summertime, when it's the wintertime, you must at least maintain 58 degrees. The thermostat must be maintained at 30 or 58 degrees. Some people will try to save money and they'll drop it down below that. And then what we have potential for? A pipe's freezing. Specific about this. All right? Assignment and subleasing. This is another area where the tenant may assign the lease or may sublease the property to someone else. In our leases that we use, the board leases, no subleasing. It's prohibited. Now, I would say that if somebody's moving out for a hardship or needs to move out and they say, hey, listen, I can find you a tenant, I would say perhaps maybe you can amend your lease to then allow that person to come in, but I wouldn't let the original person off the hook. Okay? I wouldn't allow them off the hook because you want to be able to collect if the person is not a good tenant. Now, of course, you're going to do your screening on that person as well. But if you were to sublet, transfer of most leases to a third party, that's what it means. You're transferring the leased premises to a third party. The sublessor has a sandwich lease, which means they're the middle person. Okay? Or if they assign the contract to a new tenant, the new tenant has the primary responsibility for paying the rent. The original tenant maintains secondary liability in case of default. Again, so we got to read what we want. If we're going to allow them to assign the lease to somebody, or we're going to allow them to sublet the lease. It's going to determine on who we can chase for, and who has first liability, second liability, who's relieved of liability, things like that. Okay? if the property should come under fire of destruction, meaning that the destruction of the premises, the liability to either party for the destruction of the premises is largely controlled by the terms of the lease. Now, in my leases, it also states that if it's natural causes, Mother Nature shows up and destroys the property, am I going to charge the tenant for destruction of the property? Well, no. But if the tenant, they being the lessor, destroys the property, meaning they don't maintain the property like it's theirs, they don't take care of it, holes in the wall, they've knocked out windows. I had a tenant one time broke 3 windows in the house and tried to say it was my responsibility. No, it clearly stated in my lease, destruction of the property. I gave it to you in good working order. I expected it back in good working order. That's fine. So, but you have to make sure that it's stated in the lease. Now, if there's a fire, you got homeowners insurance. You're going to make sure you're maintaining, landlord-tenant insurance. Homeowners insurance that covers tenants. It covers rental properties, and also make the tenant get insurance for their own content, because a lot of policies don't cover tenant content. All right. So the termination now, coming down the wire here for termination of a lease. Actually, we got a lot to go here, don't we? This is a big chapter. All right, we'll talk about the termination of the lease, and then we'll take a very short break, and then we'll get into the truth in renting. Sound good? All right, termination of the lease. So written leases with a defined period of time automatically expire at the end of the term. No further notice is needed to get as required. So, again, J1 to December 31st, that's the end of it. The tenant does not need to give notice. Oral or written leases that do not specify definite expiration date may be terminated by either party with proper notice. Again, if it's month to month, you would give them 30-day notice. Week to week, give them a week notice. If a breach occurs, the landlord may terminate the lease and evict the tenant. And this must be done through the court, through a process, a court proceeding to evict. And we can't have any threats, or we can't lock them out. Can't threaten violence, shutting off utilities, forcing them out under what's called an inhabitable property. Okay, so last part here, few other parts here. If a tenant abandonment of a lease, so the tenant who abandons a lease, property is still liable for the terms of the lease, including the rent. Landlord is required to try and rent the property out as soon as possible. If they do rent the property out, can they still go after the original tenant for the lease? No. If they start collecting rent again, they can't go after the original tenant for. Now you can, the thing is you can try to, but here's the thing: you don't want to cut your nose off to spite your face. So if you're looking to go after the original tenant in court, chances are you're not going to get what's due. So why not just try to rent the property out to stop the bleeding, if you will? Again, notice of termination. Here's just a quick 1, 2, 3. It's on page 167. So estate for the years, no advance notice required. Tenancy at will, 3 months notice. Periodic estates, year to year, month to month, week to week. Be 3 months notice for year to year, 1 month notice for month to month, and 1 week notice if a week. Other types of terminations that may occur is with no notice to terminate. Periodic tenancy automatically renews. Death terminates the lease if survivor notifies the lessor within 90 days of death. That's pretty key. The leases survive a sale and are binding on the new owner unless it's stated otherwise. So if you're selling a property that has a tenant in there, the lease survives the new owner. And we're going to take a quick break right there. And we'll come back and we'll... Okay. Let's make sure we're recording again, which we should be. Okay, so we're going to talk about the truth in renting now, part 1. So the New Jersey Department of Community Affairs publishes this statement every year. Okay, it's online now. It's the rights and duties of landlords and tenants, and inside that, it's a bunch of information. It's the tenant, landlord, rules and regulations, the laws, if you will. It talks about the information on eviction proceedings as well as the maintenance requirements for the landlord. So inside that booklet, again, truth in renting, it's required that you give it to the tenants at the time of the lease. It's also wise, as brokers and salespeople that we read through that book and fully understand each part of that book and what applies and how it applies, and make sure that everybody's clear on what the rules and regulations are. Because again, a lot of landlords we encounter don't know the rules. I mean, in fact, some of us don't know the rules as clear as we should. It applies to residential properties, including mobile homes. It does not apply to commercial leases, transient tenants, which is less than 1 month, and 1 to 4 family houses where three families if the landlord lives in one. So it doesn't apply there. So if you have somebody who is a landlord and they're renting out some space they have that's a triplex or something like that, it doesn't apply to that. Although I would still make it a practice to give out the truth in renting book anyway. Okay? All right, part 2 of the landlord tenant book. Turn off, turn on. Let's see if we get this thing to switch through. Of course, we always run into some technical difficulties here. Let's try this one more time. Okay. Maybe I have technical difficulties while we're recording. Okay. All right. Well, while we're waiting for that to switch over the slide, let's continue on to page 168. Okay. Page 168. So, landlord is required. Okie doke. See, that's not going to work for us. So the landlords are required to inform tenants of the names and addresses of the owners of the property, officers of the corporation that may own the building, residential managers, managing agents, superintendents, things like that. So inside of our leases, if it is in fact a property that is owned by somebody else, maybe we're managing, okay, we've got to make sure that the inside of the lease that it talks about who owns the property. Okay, and the reason behind that is because if the tenant, the lessor, is to file suit against somebody, well, if you're a property manager, you need to file it against the owner, who is the landlord, right? So they need to know who to file suit against. So it's got to be noted inside the lease if you're managing a property, who the owners of the property, the corporation, so forth, so on. Another thing we deal with. Yeah, so the one other thing that it's noted in the book here, it says on page 168, federal crime insurance. So owners of dwellings with 10 or more units must provide tenants with information on where to obtain insurance to prevent against, theft and crime insurance. Basically, that's what we call a tenant policy. Because, if the tenant's unit is broken into, is it going to be covered by the landlord's insurance policy? And the answer is no. So we have to be able to provide information for where a tenant could get a policy for their insurance. And again, like I said, in my leases, I make it it's part of the lease that they must maintain, tenant insurance at all times. Well, if they don't, because it's part of the lease, it could be considered a breach of the lease. Right, duplex that you sold, caught fire. It's the one down at the shore. Yes, okay. It was his cigarette. Yes. Correct. Yeah, see, the thing is, for me, I require that every year they provide me with a copy of the insurance policy, the declaration page. So you pay those policies in advance. It's like $100 a month. You pay $200, or maybe it's $100 for the whole year. Yeah, so $100 a year. So I require that they provide me with that policy paid declaration page. And at the end of the term, if they're going to continue as tenants, I want to see that it's been paid again. Well, here's the thing. Should the landlord go after him for that? Well, that really wouldn't be the landlord going after him. It would be the insurance company saying, well, there was a tenant there, it was the tenant's fault, and then pursuing the tenant if they're going to go that route. I don't know that gets into a whole different world that we don't get involved in. However, to prevent that from being the case or prevent that situation, having the tenant provide a paid copy of their insurance policy would, help, I would think. Well, that's it, it's whatever the policy states. So if their homeowner's policy did not state that, then no. So it's going to come down to the insurance companies and what the policy stated. Right now, yeah, it might be a rider that's added on or something like that. A lot of the policies do not cover tenant content, personal content. Okay. The Americans with Disabilities Act. The Americans with Disabilities Act has a significant impact on the responsibilities, especially on property managers and properties that have have a lot of that are multifamilies. The ADA, I wouldn't say necessarily comes down on people that have 1 and 2 unit properties or 3 unit properties, but once you start getting up over 3, into the 4 and 5 category and above, well, the ADA steps in. Okay, so they have a significant impact on property managers and what we do, building amenities, employment issues, things like that. In 1990, the ADA passed, and it went into effect in 1992. Title I of the ADA, which is that you must employ qualified job applicants with disabilities. That an employer with 15 or more employees must adopt a non-discriminatory procedure and accommodate disabled individuals to allow them to perform certain job functions. Now, the ADA came into play just like equal employment opportunity came into play first, and then it trickled down to the housing market. Just like with apartment buildings, we must provide adequate access to all individuals, meaning that if somebody is wheelchair bound, they need to be able to get into the building on the first floor, and there must be a unit available for someone like that. You can't have a unit available on the 4th floor, and expect someone in a wheelchair to get to the 4th floor unless you have an elevator. So again, providing reasonable access. Now, it may not be feasible to put an elevator in. The cost of putting an elevator in to accommodate, it could be astronomical, more costly than being an owner of that property. They have to make reasonable accommodations. So if we look on page 168 on the top right-hand side, to protect the owners of existing structures from the massive expense and extensive remodeling, the ADA recommends reasonable, achievable accommodations to provide access to the facilities and services. You want to highlight that. That's what the ADA says I want you to do. They want you to be able to provide reasonable accessibility. Under Title III, the ADA prohibits discrimination in commercial buildings. So the property manager must ensure that the disabled person has full access to the facility and the services. That's in a commercial building. That it meets the ADA accessibility requirements, constructing and retrofitting any systems or any components to allow a person with disabilities to enter the building and use the services. Which is why when you see commercial buildings, they have the wheelchair handicap accessible ramps. They have the parking designations so that people can park close to get into the building for services. So again, residential apartments have to comply as well. If you have more than 4 units, I believe is what their the recommendation is. Okay, you have to provide reasonable, achievable accommodations to existing buildings. And I think inside the book here, it also talks about this area where how much is reasonable. And it doesn't state it here, but I do remember reading it somewhere where if the cost is more than a certain amount of money, then it may be considered excessive, the retrofitting itself. And I don't see it in the book here. I remember reading it somewhere as far as like how much is too much. If it's going to cost you $100,000 to put an elevator in, are they going to enforce that type of situation on a residential small landlord situation, not on a big apartment complex, where you have 8 stories up that you must have an elevator. In fact, you're going to have an elevator anyway, because how are people going to get up and down the steps with their stuff? So you're going to have this elevator in any way, and already there. So examples that they give you here, ramping or removing obstacles from entrances, lowering public telephones, if they even have public telephones anymore. Elevating, I don't think we have them anymore, but still, it's unusual to see it. Elevators, adding raised letters and braille markings on the buttons. So we see a lot more of that happening reversing the direction of the doors as they open. It's going inward as opposed to outward so that people can get into the building. And these are just some examples. If you look on page 169 in the book, figure 12.2, reasonable modifications to public facilities and services. It gives you kind of the visual of what we just talked about. Okay. Now, rental referral service. A rental referral salesperson is required to have a written contract with every prospective tenant. And they can charge no more than $25 until the tenant secures a property. Now, what does this mean? It means that if you're collecting a fee to help them find a rental, you cannot collect more than $25. Otherwise, the money's got to be held into escrow. If you're collecting $50, and you might see a question on the test that says, a rental referral agency is collecting $50, does it have to be in an escrow account? The answer is yes. If it's more than $25, the money has to be in an escrow account. That's number one. Number two, if you're advertising a property for for rent, if you're advertising it, you must check the availability every day. That is a test question. You must check it every day if it's being advertised. If it's just listed and it's not being advertised, then you check it every 3 days for availability. Why would we check it every day if it's being listed being advertised? What would be the reason we would check it every day? False advertising? Switch and bait and switch? Saying that this unit is available and in fact it's not? Because that could be construed as a form of construed. It could be looked at as a violation of fair housing. Oh, you're not showing me that apartment? It's because I am Asian. It's because I'm Hispanic. It's because I'm black. It's because of whatever. And somebody's going to pull out the fair housing card on you, and it may not be the case. It may just be that unit that you advertised yesterday got rented this morning. In those cases, as long as you have clear evidence that that's what took place, so be it. What happens though is landlords will advertise property. Agents, especially not landlords, agents will advertise property, and it's not available. Same thing when we have something that's under contract. Is it still available? Well, just because it's under contract doesn't mean it's sold. However, we can't get into that bait and switch situation. So the questions are going to be asked about how much escrow, how much money we can collect as a service fee before it's going to escrow. The question is going to be about check the availability of an advertised unit. It's 3 days, or it starts every day. And if it's just listed, it's every 3 days. Okay? Rent control is another area that some communities are involved with and enforce. Rent control regulations are set by the individual communities. Up to 25% of the municipalities in the state of New Jersey have rent control. The feature here is it controls annual rent increases, so a landlord cannot take a $1,000 rental and then, because the market's hot, all of a sudden charge $2,000, excluding people from being able to afford that, people of moderate and low income. Of course, the drawback is it discourages investors. Because as an investor, you get a property that's hot, and you can get what the market's bearing, which is more than what you charged the year before. You should have the ability to do that, right? Well, rent control communities do prevent that from happening, and it is a drawback. Most limit the allowable yearly rental increases. What is a good rental increase? Yeah, I'm not really certain if there's a number that we can say this is a good number or a bad number. I like to go with what's called the cost of living raise, perhaps maybe in increments of a percentage, an escalation percentage, which could be perhaps 3 or 4% as a reasonable number. Do people get paid at their employer based on the cost of living raise? They don't nowadays, but they used to. So it's a reasonable number if you say, hey, we're going to increase by the cost of living, and you find out the cost of living index is up 2%, and you raise the rent 2%. Okay, it's really subject to the owner and what they want to do. You don't have to raise the rent at all. You can give a good tenant. You might just want to keep the rent at where they can afford. Now, if you're charging too low of rent, say you're charging $500 on a unit that should be $1,000, you charge them $500 for the first year, second year is $1,000. Well, if you're in a rent-controlled area, that might be a problem because the rental increase is doubled. So we got to be that. Okay. As we start to come down the stretch with regards to some other areas, the eviction process, well, the eviction process is just that, it's a process. It cannot occur without a court order. You can't just, on your own, evict a tenant. Now, you can certainly do some things to try to get them out, to release them from this tenancy at sufferance. You know, send them a certified letter demanding that they release the property immediately. Okay? If that doesn't work, and again, I think that many landlords fail in this area where they wait because they want to be nice about it. Like, oh, I'm just going to be nice about it. I know you're going to get it to me. You've been good so far. But once we let the tenant out on a leash, you know, on a short leash or a long leash, what's going to happen is that 1 month's going to turn to 2, 2 is going to turn to 3, and now you're 3 months in with no rent, and you got to go to court to evict them, which the court may then allow them up to 6 months to find another housing situation based on a hardship. You don't get paid. It costs you a couple dollars at the courthouse, $35 or something like that. You can enter and you file it. It gets served by the sheriff. It's going to probably scare somebody into, you know, paying up the rent, paying what they owe. Now, of course, if they are having a hardship, I mean, it's going to be subject to. You may have a heart for people. I'm not saying being ruthless, but at the same time, you give an inch, they're going to take a yard. And we have to also know what the rules and regulations, the laws are. You can't just go shut the water off. You can't shut the electric off in hopes they're going to pay. Now you're in violation. So we have to make it clear to our clients, the landlord, if that's who we're representing, that that's the process and that's what has to happen. Don't wait. Don't wait to collect. All right? Be nice, but don't wait. Condominium and cooperative restrictions also apply. So if you have a rental property that's in a condominium association or cooperative, there may be some restrictions as far as if you can lease it or not. Definitely want to check that out before you purchase it as an investment property. And again, most common reasons for eviction would be non-payment of rent, a failure to pay rent, and damage of the property. Now, I had to evict a tenant for failure to enjoy quiet enjoyment. In my leases, it says that the tenant will enjoy quietly the property. I had one tenant who decided to run a brothel out of my rental unit. Nice, I know. That's no joke. I'm not joking about that. Rent was always on time. Didn't share any of the profits, but she was running a business out of my property, which is a violation of the lease, albeit an illegal operation. But it wasn't until I got complaints from the neighbors and complaints from the police department that I had to address the issue, or undress the issue, whatever you want to say. Long story short is, of course, she never admitted to it. I never proved it, and I just said, look, let's just part our ways before this gets a little bit out of control, and we have to take other measures. That's right. Before we gotta take things to another level, let's just go ahead and let's part ways. So that worked out. But again, her deal was not failure to pay rent. It wasn't destroying the property. It was, you know, not quiet enjoyment. Yes, sir. Quiet enjoyment, yeah. Yeah, I mean, it runs rampant. It's not like it's just, you know, I gave you the example of how it worked for me. I mean, or you know, my situation. But yeah, it could be anything. It could be that, you know, they're just like noisy, out of control, having parties on the weekends, and people complain, and you get an ordinance in the town that has a noise ordinance, and you're getting called in the middle of the night because you're the owner of the property, or you're the property manager. I mean, you know, there's a time where you got to say enough's enough. Yes, our leases do state that. My leases I use for my personal stuff does state it as well. Breach of contract. Well, to enjoy it. Well, the right to enjoy it, but it says the right of quiet enjoyment, and it's open for interpretation. So if my idea of quiet is to be extremely loud and hostile and party all week, then you're not the right tenant for me. You know, it's not the right fit, because there's going to be also compliance with the local ordinances. Like if there's a noise ordinance at 10 o'clock and you're at 12 o'clock and you got the sound system out front, DJ in the front lawn, you know, we got problems, right? Well, you're guilty. You're innocent until proven guilty. So again, yeah, the police come out, they issue a citation. Okay, now you've been not charged because there's no court of law, but the citation is enough to say that yes, you were cited for being too noisy.
That's how it.
Yeah, I mean, it can come down to, again, and sometimes you tolerate stuff, but if you do your screening up in advance and you have these conversations in advance, I think that it eliminates a lot of problems going forward. All right, let's talk about a couple things here you need to highlight in your book. Constructive eviction, what does that mean? It means the landlord fails to provide basic services necessary for human habitability. That's called constructive eviction. Whereas if the heat's not adequate or it's turned off or the electric's turned off or not adequate or if there's no water, the tenant may claim constructive eviction, which means that they may move out and cease paying rent. However, they can't move out first and then claim constructive eviction. You've got to claim constructive eviction first. I'm sorry, I just said just the opposite. Tenant must vacate the property before claiming constructive eviction. Okay, I just said it backwards. I have a little dyslexia today for whatever reason. Yeah, must be, I didn't have enough coffee or something. Tenant must vacate the property before claiming constructive eviction. So they can't just claim constructive eviction and then move out. Because if they do that, then the landlord's been put on notice that there's a problem, they have to comply and fix it. Yeah, there's some places where the tenant provides heat. Let's say that the tenant's, it's a multifamily, you got 3 units and there's 1 furnace. Situation like that. So constructive eviction is where the key to the constructive eviction is where the tenant induces it, or I'm sorry, the tenant initiates it. Where actual eviction, again, let's go back, should consult an attorney, but actual eviction is when the tenant breaches the lease. So constructive is when the landlord, I'm getting myself confused. Constructive is when the landlord breaches the contract, meaning they don't provide heat or something like that it's not habitable. And actual eviction is when the tenant breaches the lease or improperly retains possession of the premises. The landlord may do a couple things. First of all, they can bring suit for possession or a summary proceeding to recover the possession of the property. The process called actual eviction is when the landlord takes action. Okay, and notice has to be first filed, given to the tenant, and again, doing it by way of a letter, certified letter, proving that you did proper service is all the way to go. Again, we got to file the details, because when you get in court, the judge is going to say, did you file a certified letter? No, sir, we did not. Okay, did you give him a letter? No, sir, I told him by mouth. Okay, so do we actually have it's he said, she said now? It now eliminates a whole bunch of things that could happen. Attention in the details. Here's where we talk about the causes. Again, non-payment of rent on the top of the list. Disorderly conduct, 3 days notice before filing. Destruction of the premises, again, 3 days notice required. And you can see all that stuff inside of the handbook. So, what we got here? Looks like we have a pop quiz. This is the music. Alrighty, so it is a new offer. Whatever reason the screen's not working. All right, so anyway, so a new offer made on an offer that was received is called counteroffer. Okay, did that in the last chapter's contracts. Now, I always refer back to My Cousin Vinny. My Cousin Vinny, anybody watch it? That's a great movie. It was just on again last night or the night before. I could watch it every time, never gets old. But in that, it's funny because the movie, My Cousin Vinny, right? Joe Pesci plays a New Yorker who was a street kid, goes to law school, and then his fiancée, Marissa Tomei, they're typical, I guess not typical, but sociotypical New Yorkers, and she's smarter than he is. And she's a hustler. I mean, literally, she's in the bar while he's trying to try a case down in Georgia or Alabama, whatever it is, Mississippi. And she's in there hustling, playing pool, hustling the locals. She wins, and now she wants to collect her money, and they won't give her money. So Joe Pesci comes to the bar to collect the money, and he talks about an offer and a counteroffer. And it's just funny how he presents it. This is comical. If you like movies. Yes, gets most of the time. It never gets old. It's like watching Ferris Bueller's Day Off. Never gets old. Never gets old. Okay, so types of leases now. We're going to talk about the types of leases that we have. There are different types, and this is going to be stuff that's on the test, okay? This is stuff on the test. We have a gross lease, net lease. We got a percentage lease. Other types of leases would be variable leases, ground leases, oil or gas leases. Gross lease is when there's just a flat fee. Tenant pays a flat amount, and the landlord pays the taxes, insurance, and mortgage payments, repairs of the property. It's the most often used for residential properties. Gross lease. Questions about this? Net lease is where the tenant pays the rent and some or all of the property charges. This is really a good example of retail. Or it may even be an office. Whereas the rent income is the rent is a net income to the landlord. And with ground leases and commercial retail, a triple net lease would be where the tenant pays the rent, taxes, insurance, and all property expenses. But the tenants, and here's the key word, here's the caveat, tenant does not pay debt service. Debt service is a word that we haven't learned yet because we talk about mortgages in the next chapter. Debt service in investment property and in commercial is the mortgage. Debt service equals mortgage. With residential property, we call it mortgages. So with a triple net, the tenant pays the rent plus a shared portion of all of the other expenses. Now, if you have multiple tenants, then the expenses, taxes, insurance, it could be electric outside for the lights for the parking lot. It could be trash removal. We call them CAM charges, C-A-M, common area maintenance charges. They can then be divided proportionately to whatever that space is to the total property. So if you got 4 units and everybody's equal, 25%, 25%, 25%, then they would pay 25% of all those expenses on a monthly basis, in addition to the flat fee. Next type of lease we have is called percentage. This is more so for big box shopping malls. We say big box, I'm talking about big box retailers, where you may have good months and bad months. What happens is there's a rent based on a percentage of the gross income received from doing business on the property. So if you're a box store, say like Ross, Marshalls, or any of those big box stores, and you're paying, say, I don't know, $20,000 a month for flat rent, for the rent base, and then say 5% of the gross sales that exceed a certain number, then that's what the landlord gets paid. So if you're a company, say like those big retailers, and their take for the month was say $150,000, $200,000 for the month, and you're getting 5% of that, that's not a bad deal, right? That's $2,000 times 5, which is $10,000 plus your flat fee that you would be paying for rent anyway. Yes. Yes, so on big stores like that, it's not going to be something for mom and pop stores. You got a mom and pop deli, they're going to probably be paying a flat fee, not even a triple net. Probably just a flat fee because, again, it's not common for smaller retailers because they can't afford it. If you have a big store like that, yeah, it might be a way for them to kind of ride the wave with, landlord rides the wave with their cyclical business. All right, that's very common. So you're going to get quite regarding that. Page 171, the table 12.2, types of leases. Again, this just kind of lays it out for you in more of a visual setting. You have a variable lease. It allows for increases in a fixed rental charge during the lease period. So this could be like a graduated lease. For example, this month you're 1,000. Next year you're 5%. After that it's 6%, 7%, 8%. Or it could be in a dollar amount where this year you're 1,000. Next year you're 1,100. Year after that you're $1,200 a month. It graduates up or down. An index lease would be an increase or decrease in the rent periodically based on the changes in the government cost of living index. We talked about that. So if you were going to add in increases, you may just want to go and look at the index, the cost of living index, to see whether or not it's 3%, 4%, and then increase your rents that way. So those as you drive around towns, you'll see these things called ground leases or build-to-suit. This is where somebody owns the ground and they want to rent it out. This is great for retailers, especially like Checkers, that little hamburger place. Well, they don't own the land that their stores are on. They rent the land and they come in. Their system is actually pretty interesting. It's a modular system. They bring the hamburger shop in on 3 or 4 trucks. They'll build a slab, all the stuff they need for the water and the gas lines and electric and all that. They bring these boxes in modular, they drop them down, secure them down, and whammo, in 2-3 days they got hamburgers flipping. That's pretty cool. Checkers does that. Some other stores like Walgreens, now I'm not so certain if they own their ground, but CVS, Eckerd Drugs, they own the building. They don't own the land. They lease the land, and they build their own proprietary building for their design. They build that on that lot. Well, the benefit is the benefit could be taxes. The benefit could just be that if you're an owner and you got a piece of land, especially commercial land, you can do anything you want with it. You build something on there, now you got to maintain the building. Whereas you leave it to the tenant to build out, fit out. All right, then now they're responsible for all that extra expense. So if you just buy a piece of land for $100,000 and you can get lease, let's say a monthly lease of $5,000 to $10,000 a month, it's a great opportunity.
It's not. See. So.
It really depends. They may not have the ability to buy the land. They may not want to, based on being able to take. And now, if they get rid of that location, now they own land. They got to sell the land. Now it's a debt now, not an asset to them. So again, as an investment, I know a few investors that's what they do. They own land, and they do ground leases. What a great idea! Great idea. So the landowner leases the land to the tenant who agrees to erect the building on it. Long-term lease will offset the initial cost, making the investment in the building. That's kind of what it is. So it's a long-term investment for the building, the tenant. Generally, net leases are then required where the tenant pays the taxes, insurance, and so forth and so on. A built-to-suit is being offered here, where you may be a builder. In construction, you build as part of the cost. Again, it's all feasibility in terms of the project. Leases run for quite a while too. If you own property and you're fortunate to have some special things called oil and gas, you may be able to lease out your property. You may be able to lease out what's called a special lease for exploration purposes. The lease will continue as long as the oil and gas are obtained in quantities. Maybe you get a percentage plus the flat fee. Maybe you lease out your farm for $5,000 a month plus a percentage of what they extract from the ground. It's kind of fun. Oh, we got another pop quiz here. Apparently we do. Oh, we're just full of pop quizzes today. Yeah, kicking it down. Yeah, right on. All right. So in a land contract, financing is provided by the owner. That's right, the seller. Correct. Yeah, so in a land contract, financing is held by the seller. That's what they call it. We don't really get involved in doing those type of things as owner financing. It requires an attorney to draw up for that. Okay? Now, talk about property management. This is a great field. We can, as brokers and agents, get into property management. New Jersey does now require us to be licensed, which is kind of fun. If we're providing that as a service to someone else, getting paid for it, there has to be a license, there has to be a property management agreement. If you're an owner and you want to manage your own property, there's no requirement for you to have a license, right? You can own property and lease it out. You're your own property manager. But if you're going to do it for someone else for a service, for a fee, you need to be licensed. The use of the professional managers, that business is growing. I think more so now than ever. Because people don't want to deal with the headaches. And for the fee that you would pay, especially in residential, it's worth just paying somebody to do that. Great add-on to our business. I know agencies that they'll sell the property to the investor, they'll manage it. And if you do enough of those, voila, you got yourself a salary plus sales business. This is especially true for commercial real estate. If you want to do, it's a specialty. Commercial leasing, there are agents that specialize just in retail or office space or industrial space where they're renting it out. And they're getting paid a fee to manage. Fee could be crazy in the six-figure income type. If you have 1 million square foot of space that you want to rent out, and you're getting $1.50 a square foot, or say even $1 a square foot as a management fee, think about it. That could be a nice, handsome salary. collect rents and make sure everything's maintained. So, if you get enough business like that, I mean, the leases will run. And the idea, I know one particular agency up in Cherry Hill, that's what he did. He went full throttle for like 5-6 years. Had every connection in the world, but he went full throttle for 5-6 years. Got more than $5 million worth of office space under contract to lease, and then got it all under contract with different companies that ran, anywhere from 3 to 10 years. So every year, something's either renewing or something is coming up for renewal. And he gets paid a fee every month to maintain those. So it could be a declining fee. It could be like a 5, 4, 3, 2, 1, 5%, 4%, 3%. But imagine that $5 million worth, and if he's getting a management fee of $1 a square foot, it's not a bad deal. Not a bad deal. Plus, you maintain the relationships with those people for any future business they have. And if they want to buy stuff, now you can, in some cases in your contract, you can even put in there that if the landlord decides to sell it, that you'll be the listing agent. Well, if you're with your broker has to be, if you want to do property management as an agent, as a broker, your broker that you're working for has to have a property management agreement in place. Not all firms do that. It's a specialty. You have to separate. There's not one in place here, but there is a division of, it's somewhere in the region where that's what they do. You can refer business to them, but we particularly don't have one. It is somewhat of a headache because you have to have separate escrow accounts, deposits, you have to have accounting, you have to have accounting system. There's a lot that goes into it, there's a lot more moving parts, I think. But I do know a couple successful brokers in the area that have companies, that's all they do. And in fact, what they'll do is they'll help out agencies where they don't do property management. So you can refer them the client for property management, and when it comes time for them to buy or sell, they send them back to you, which I think is kind of neat. Right? So what are the functions? Well, the function of the property management manager is this. You need to highlight this. This is a test question. Is to preserve the value of an investment property and generate income as an agent for the owners. That's your job as a property manager, is to preserve the value of the investment and generate income for the owners. Okay, that's your primary job. If that property fails in terms of its income or fails in terms of its value, it's the property manager's fault because they didn't do something to maintain it. It's a huge responsibility, and it's a responsibility that you could be sued for, and it's a responsibility that you could possibly be suspended or lose your license for incompetence. All right, so we got to be careful when we enter into these agreements that we're doing the right things. Property manager is also there to merchandise the property, to control expenses, maintain and modernize the property, and preserve capital investment. Again, you're there to preserve the owner's investment. You're also there to secure suitable tenants, collect rents, care for the premises, budget and control expenses, hire and supervise employees, keep proper accounts, and make periodic reports to the owner. You should be reporting to the owner every 30 days on the progress of their investment. And in fact, most contracts, property management agreements will state that. They'll also state how much control you have. Is there a certain cap on what you're allowed to spend for general maintenance? And when do you have to go to the owners for something big? Let's say they need a water basin to be fixed or to be installed. All right? You do have carte blanche to just make that decision. And you have to budget for the capital improvement. So there are some limitations, but they're all spelled out inside of the contract. Okay, the management agreement itself created an agency relationship between the owner and the property manager. Property manager is usually considered a general agent. Highlight that because that's an important question. They're charged with the same responsibilities of agency. Number one, notice the disclosure, obedience, care, loyalty, accounting. That's the COALD. Talked about the previous chapter. We still have a fiduciary responsibility to our client. Additionally, any property that you're managing, make sure you have a proper description of the property, time period for the agreement, manager's responsibilities, the extent of the manager's authority, reporting on the operation and financial status to the owner, when you're going to do that, how often, management fee percentage, like how much you're making, cost to be paid by the owner. You're also responsible for budgeting, renting the property, of course, maintaining the property, and insurance. You got to get all those parts. It's a great business to get in, by the way, I think. I often thought about if that's something I would do when I grow up. But it takes a lot. You gotta have, I guess, protocol in place so you're not getting those calls all hours of the night. Especially if you're dealing with weather conditions where pipes are freezing and breaking, or tenants. Unless you open up your own shop as a broker, yes, you still need to work for a broker. Someone has to be. Now, you can only work for one broker at a time. So if you're a broker and you want to set up your shop as a property manager and work for somebody else to do sales, you can't do it. You can only work for one at a time.
No, I mean, like if you did do sales.
You could. Yeah, if you want, as a broker, you could be the broker of record for that property management company. Sure. 100%.
Do they need a record?
Yes. Yes, you still need a broker of record because you're still providing a service, real estate services, and in the state of New Jersey, you're required to have a license. In fact, property managers, the manager itself needed to have the license, right? And the leasing agents underneath that person did not until 2014. Now they do. Because in 2014, we started getting tons of calls from people to say, hey, I got to have this license by the end of 2015. Flooded our school with people coming in. Yeah, it was interesting. Absolutely they are. 100% they are. They need to have a license. You know? So again, the property manager is responsible for optimizing the property and keeping and maintaining the value. Property manager, again, since a broken record here, they should set some rates. Basic concern is the rental income will cover the fixed charges. So we make sure that the fixed charges are covered by the rental payments. You do some comparable analysis, find out what the current vacancy rates are, find out whether they're too high or too low. Because you can have a great product and be outpriced at the market if it's not where your building is, where it's located. You're not getting the rents that it uses. Okay, and go through the process of tenant selection. It's important. Tenant selection is so important. Not only for us to get a good tenant, but to make sure we're providing them with a good service so that they want to be a good tenant. It's a two-way street. And if you have a property that's a POS and people feel like they're living in a POS, well, guess what? Chances are you're going to have problems. They're not going to take any pride. And when it comes time to pay, they may not be your best tenant. They're going to use their own. So tenant screening is very important. Maintaining the property is just as important as screening the tenant. You can't let things go to disrepair, because if you let them go, it's going to create other problems, and before you know it, the property's going to fall apart. But again, satisfying tenants' needs will minimize your operating expenses because they'll want to take care of the property and therefore making it easier on you as the owner or property manager. We talked about it again, we'll talk about it again. Property insurance, again, you're going to have homeowners insurance on the property. That's to protect the investment itself, but also have insurance to protect their own personal property. Once you get into property management, there's a bunch of organizations you can join, you can be part of. As the NAR, National Association of Realtors, there are some designations you can get. One of them would be the CPM, or this is a Certified Property Manager. There's different levels of that. You have the Institute of Real Estate Management, the Certified Property Manager organization, and quite a bit of other ones that are out there that you can get involved in. And that, my friends, is Chapter 12, Leases, Landlord, and Tenant.